Are there any other votes? Announce the results.
Ayes 110, noes 1.
The bill is passed.
Assembly 10,496B, Rules Report 506. Mr. Noje, an act to amend the real property tax law.
On a motion by Mr. Noje, the Senate bill is before the House. The Senate bill is advanced. Read the last section.
This act shall take effect January 1st.
Clerk will record the vote. Are there any other votes? Announce the results.
Ayes 97, noes 15.
The bill is passed.
Assembly 10,584, Rules Report 507, Committee on Rules, an act to amend the tax law.
Read the last section.
This act shall take effect January 1st, 2017.
Clerk will record the vote. Are there any other votes? Announce the results.
Ayes 109, noes 0.
The bill is passed. Mr. Morelli.
Thank you, Mr. Speaker. I'd like to just give some direction on the next couple of bills I'd like to take up. First, Rules Report 438, which is on page 3 of the A calendar by Mr. Simanowicz. And we'll follow that with calendar number 308 on page 35 of the main calendar by Mr. Buchwald.
Senate 4430D, Rules Report 438. Senator Felder, an act to amend the public health law.
An explanation has been requested. Mr. Simanowicz.
Thank you, Mr. Speaker. This bill would amend Section 4211 of the Public Health Law by limiting, or actually prohibiting, delivery of unclaimed bodies to universities, colleges, schools, or institutes of embalming, dissection, or autopsy until consent of the deceased person's next of kin is acquired.
Mr. Garbarino.
Thank you, Mr. Speaker. Will the sponsor yield for a couple questions?
Will you yield, Mr. Simanowicz?
No. Oh, okay. Yeah. Yes. Yes, Mr. Speaker.
The sponsor yields.
That would have been very quick. Can you please explain how this changes current law?
So currently under 4211 of the Public Health Law, the mortuary, in the case of New York City, is the medical examiner of the city of New York. New York City is the only municipality in the state where the medical examiner is also the mortuary, would have 48 hours to deliver any unclaimed bodies to the various medical schools or mortuary schools for dissection, embalming, or whatever other practices they would have on there, whether or not they can take into consideration the deceased's religious beliefs, whether they be Jewish, Muslim, Christian, if they have an objection to it. In many cases, there's we're dealing with indigent people. Many of them are immigrants. Most of their families are not local. So to do the search properly for the medical examiner's office would take probably in excess of 30 to 60 days, maybe even 90 days. But under the law right now, the medical examiner is required within 48 hours to turn over those bodies, thus opening themselves up actually to lawsuits from family members for limiting their right of sepulchre. Right now, a family member has a right to decide how they want to dispose of a body. So in order to prevent themselves from being sued, the medical examiner currently would actually have to violate the law.
Okay. So is the only reason that this is limited to New York City because that the city acts as both, or the medical examiner is both the medical examiner and the mortuary? Is that the only reason why?
Yes.
Okay. Now, here's a question. Can medical schools in New York City receive unclaimed bodies from mortuaries outside of New York City? Or would they be prohibited from receiving any of them?
Yeah, they could.
They could?
They could receive from outside New York City, yes.
Now,
And by the way, just to clarify, the medical this body has spent a lot of time over the last number of years since I've gotten here, and rightfully so, talking about organ donation and the importance of organ donation. Right now, in this state, you can't harvest organs without consent. Why should that change when the person is deceased as opposed to just brain dead? Here we're talking about, and by the way, the medical examiner has offered the medical schools that they will provide the medical schools with names, with whatever next of kin information they have to get that consent, to insist them in getting that consent. I mean, oftentimes the medical examiner is told by family members, we're going to release the body to you for city burial. In those instances, they would be able to get that information and perhaps get those bodies to the medical schools.
you said here that they can't, they're prohibited from delivering the bodies to the medical schools unless they get consent from the next of kin, correct? Under the
Or if the decedent has a will that makes such a donation, or has a card in his wallet that says he or she wants to donate their body to science.
I'm sorry.
No, go ahead.
So under current law, who is responsible for contacting the next of kin?
The medical examiner.
Now under your bill,
Whoever has the body.
whoever's the body. Does your bill change that?
No.
So your bill does not. I'm just reading here. It says the person or entity having the possession, charge, or custody of the body of a deceased person shall have no duty to locate or obtain the written consent from the person from the person under this subdivision. So if they have no duty,
Correct. They're not going to obtain the consent. They'll find the next of kin and give that information to the medical school, and then the medical school can, or the mortuary school can then get consent from the family. The same way that it happens right now with organ donation.
I mean, okay, I understand. I guess that's the intent. But looking at the language, it says it shall have no duty to locate. So if it doesn't have a duty to locate,
No. So under the right of sepulchre, they have a duty. The mortuary has a duty to find the next of kin in order to dispose of the body. Trust me, the city medical examiner doesn't want to be burying thousands of bodies every year. It's in their duty bound to give the family the right to dispose of the body as they see fit. In this instance, though, if it were the desire for the family members not to take the body and dispose of it themselves and have the city dispose of it, the medical examiner could then give that information to the medical schools, and the medical school can obtain consent and get the body.
are they?
The public administrator does not have a duty to find.
Are, my concern is, if they're, I mean, based on the way I read the bill, it looks like that they don't have to get consent, or not consent, or locate the next of kin. But my concern is, if they give, are they legally allowed under HIPAA laws to provide the information to the medical schools?
Yes, they do it right now They do it right now for organ donation. They're already doing it for organ donation. This would just be an extension of that.
Well, I'm pretty sure.
And my understanding is that HIPAA doesn't apply to the.
I'm pretty sure HIPAA applies once somebody's deceased. It still applies.
There's an exemption for medical examiners and coroners in the HIPAA guidelines.
Okay.
Am I bothering you?
All right. So the intent of this bill is, I mean, is there a specific reason why we're doing this? Because I've got a lot of memos here from the medical schools, the mortuary schools, the Funeral Directors Association, the Greater New York Hospital Association, all opposed to this because a lot of them rely on these cadavers to teach the students.
I wonder if you would ask those medical schools if they would take the bodies themselves. So right now, under the law in the city of New York, right, if a patient dies in XYZ hospital that happens to have a medical school attached to them, right, the hospital holds the body for X number of days. The hospital could very easily just transfer that body, under this law, under 4211, that hospital could transfer that body to the medical school without even involving the medical examiner's office, and then use that body for their gross anatomy class, for their plastic surgery class, for whatever it is. They could do that right now, but they don't do it because they don't want to assume the responsibility of the liability that comes along with the rights of sepulchre. I mean, right now there's a case that then, am I talking out of turn if I talk about this case? There's a case right now of a woman, an ex-wife and a daughter from New Jersey who are suing the suing the medical examiner's office because her husband and father died 3 years ago and has been sitting up in a medical school being dissected as we speak.
Well, since they're next of kin, couldn't in that specific case, couldn't they have revoked the consent?
Too late. It's already the body's already dissected.
So I want to go back to the point you just made about the school just transferring over. Doesn't this bill prohibit the university from taking the body or any transfer to a university, college, or school without the consent?
Correct. I'm saying on the current law. The medical schools could do that.
They could just without.
They could just do it without. They don't have to send the body to the medical examiner's office. They could under current law, under 4211 right now, the medical school, the hospital can transfer that body from their morgue to the medical school and dissect that body. But they don't.
They're still required to do the next of kin search and everything. They're still under the law. They're still required to do the process. I mean, at 4211 sets up the whole process for how they deliver the bodies.
Yes, but within 48 hours, they have an obligation to deliver that body to the medical school. If they can't find somebody within 48 hours, they have an obligation to do that.
It's 48 hours within someone claiming it, or I think it's within 24 hours of them sending out notices. So if they have places, they have to send out notices and wait to hear back before they can also. I mean, if they don't, my reading of the law, I believe they are. If they have any information,
my information is within 48 hours, the body becomes property of the city.
Oh, okay. You're talking about the
currently.
Okay. Now, is there another way? I mean, I understand the concern about people not wanting to have their bodies dissected. Either religious or personal reasons. There currently is under 4209 a provision that would allow people, if they don't want that to happen to them, they could carry something on them that says they don't want that to happen to them.
Correct.
So I mean, wouldn't that if somebody doesn't want it to happen to them, isn't that good enough? Isn't there already provision in the law that takes care of this situation?
Well, in my experience, indigent people don't generally carry wallets, but for that matter, under organ donation, they can carry a card as well. I mean, we're not trying to. Listen, the medical examiner's office, they're all doctors. They all went to medical school. They all got training. They want the medical schools to have the bodies. They want the medical schools to succeed. They just don't want to be sued for it. So, I mean, they've come up with a solution that, quite honestly, I think will help the medical schools at the end of the day get these bodies more timely, get the bodies needed, which I think we're talking about a shortage of between 30 and 35 bodies a year that we're estimated at. And I think that's well within the number of bodies that are currently being buried by the city of New York because family members don't want to claim the bodies.
Thank you, Mr. Simanowitz. On the bill?
On the bill, Mr. Garbarino.
Mr. Speaker, I understand and respect the intentions of this bill, but I've been reading a lot of opposition memos, like I said, from the medical schools, the Hospital Association, the Funeral Directors Association, and there's a major concern if this bill becomes law that they will not be able to get the bodies that they need to teach the classes so that the doctors can learn, the dentists can learn about how to save the people that are still living and learn the anatomy that they need to learn. So, you know, I understand the intent, and I think there is another way to do this, to get this done without passing this bill. And I think we just need another try at it. So I'm going to encourage my colleagues to vote in the negative. Thank you very much.
Mr. Gottfried.
Thank you. Mr. Speaker, will Mr. Simanowitz yield for a
Mr.
question?
Simanowitz, will you yield?
Absolutely.
Mr.
Thank you.
Simanowitz yields.
If it's
We're
brief.
going to do one of our script things again. Mr. Simanowitz, I want to make sure that if the decedent had indicated an intent to make an anatomical gift that would include delivery of the body that is the subject of the bill, then the decedent's intent will be honored. Clause 1 on line 7 of page 1 says that the body may be delivered if the person authorized to consent to make an anatomical gift with respect to the decedent under Article 43 of the Public Health Law has made such an anatomical gift. That can be done in a variety of ways and doesn't necessarily require a written document. But Clause 3 on line 1 of page 2 refers only to the decedent consenting through a lawfully executed written document. I am concerned that this could be interpreted as narrowing Clause 1. Is it the legislative intent of the bill that the decedent's intent under Clause 1 must be honored even if it is not expressed through a written instrument under Clause 3?
Yes, that's the intent. The decedent. The decedent's intent would be accepted whether it's under Clause 1 or Clause 3.
Thank you very much. Just very quickly on the bill, and that little exchange is important, I think, to making sure the bill reads the right way when it's in practice. You know, under New York law, if, you know, when someone dies, if their organs are good enough to donate for transplant purposes, we do not do that unless somebody authorized by law says so. But if your body is basically unclaimed and nobody shows up, then your organs can't be used for transplant, but there is effectively a presumption that your body can be sent off to a medical school to be a cadaver in an anatomy class. Now, I think a case can be made for establishing a presumption in favor of organ donation where a life or several lives could be immediately on the line. But I do find it troubling that there is now effectively a presumption that an unclaimed body gets delivered to a medical school for anatomy class purposes. This bill would reverse that presumption and say a body only gets sent to a medical school class if there is reason to believe that either the decedent or appropriate family members want that to happen. I think that's reasonable. That's what the bill would do, and that's why I'm going to be voting for it.
Mr. Palumbo.
Thank you, Mr. Speaker. Real quick, will the sponsor yield?
Will you yield, Mr. Simanowicz?
Sure. Thanks,
Mr.
Mike.
Simanowicz yields.
Thank you, Mr. Speaker. I'm wondering, Mike, is
Excuse
there,
me,
an,
Mr.
is there an
Jones,
outside date?
cooperate. Excuse me?
It's getting late. I'm trying to talk quickly. Is there an outside date upon which the ME has to stop looking for next of kin?
No.
So, in the event they have exhausted their search and they have not located a next of kin, when can they ultimately dispose of the body if they've exhausted all remedies to otherwise or
So right, so
efforts
they,
to
they
otherwise
could
locate?
they could inter the body intact in the city burial plot, and then if a family member does come up 3 years later, they would exhume the body and hand it over to the family. Unlike a medical school where you would be handing over bits
I
and
get it.
pieces.
So they otherwise would be able to dispose of the body after a
Correct.
period of time. Okay,
Correct.
thank you. That's all
You're
I wanted to know.
Read the last section.
This act shall take effect on the 30th day.
Clerk will record the vote. Are there any other votes? Announce the results.
Ayes 92, noes 28.
The bill is passed.
Assembly 7704, Calendar 308. Mr. Buckwald. Concurrent resolution of the Senate and Assembly proposing an amendment to Section 7 of Article 5 of the Constitution.
An explanation is requested. Mr. Buckwald.
Proposed state constitutional amendment to allow the removal of taxpayer-funded pensions from public officials if they are convicted of a felony in connection with their job. Thank you, Mr. Speaker.
Mr. McKevitt.
Sure. Will the sponsor yield to some questions, please?
Will you yield, sir?
Yes, Mr. Speaker.
Sponsor yields.
I just want to make it clear to everyone in the chamber tonight as to exactly what we are discussing and voting on tonight. If we just want to go back a little over a year ago, and certainly you have introduced numerous bills in order to try to provide for the forfeiture of pensions, particularly for those officials who commit felonies in office. And certainly there's been a great public outcry for those officials to be receiving pensions after they've been convicted. So there was a time going back in the budget process as we were ready to go and finalize the budget in 2015. We were informed, or many members were informed, that there was a three-way agreement between the governor, this House, and the Senate on a proposal for a type of pension forfeiture constitutional amendment. And that bill actually, that resolution was approximately a 9-line bill, which just simply said that a public official who is a member of the pension system and who have been convicted of felony is considered to have breached their relationship with the people in the state, and they shall be subject to forfeiture. That's not the bill or resolution we're voting on tonight. We're actually voting on a different resolution. So can you tell me what the difference is between that resolution that we thought we had a 2015 agreement on and the resolution for a constitutional amendment we're doing right at this moment?
Of course, Mr. Kevin, I'm glad there was finally a question there for me. First of all, I'll correct one item in what you said earlier. It was exactly 1 year ago today that we voted on this very constitutional amendment here in the State Assembly.
Right.
And this House passed it by a vote of 132 to 13. This bill lays out in more specific language how the pension forfeiture process would work. It specifies which officers in New York State are subject to pension forfeiture. There are a number of different criteria, but broadly speaking, they are elected officials and policymakers in New York State, those to whom we place the most trust when it comes to guiding New York State. This bill also establishes the procedure for removal of pensions, making sure that judges, for example, have discretion so they can decide whether to remove all of a pension or some of it. It also provides protections for dependents and ensuring that, for example, public officials are entitled to get back their own money that they put into the pension system. What we are focused on is the taxpayer-funded portion of that. And then the last thing I'd say that's in this resolution that wasn't in the earlier Senate version is that this version of the Constitutional Amendment specifies that it only goes into effect after it's been adopted by the people of New York. That would have implicitly been true of any constitutional amendment on this subject. The federal Constitution mandates that there be no ex post facto provisions. You cannot increase the punishment for a crime after the fact of its committal. We lay that out explicitly in this constitutional amendment that we put forward today. But I would say implicitly that would have been there even under any proposal on this front.
Just one interesting thing about my understanding, though, is that the original, again, 9-line version of the constitutional amendment, which was being considered in March of 2015, that does not go and state what the whole process will be. It just really enables what this legislature can do as far as those parameters are concerned. That's generally how the Constitution is drafted. The Constitution, even though our state Constitution is certainly much longer than the federal Constitution, but it really just gives the framework as to what powers are given or taken away from this legislature, and then we could do, under our own statute, go and make the more specifics of it, and also modify from time to time. You know, if there are situations which we found worked or didn't work, or situations which didn't arise out of it, this legislature could then go and amend from time to time if that were the case. What I think we see before us tonight is actually a 48-line proposed amendment, which goes into significant more detail, like you said before, as to how it deals with perhaps spouses or children who may be receiving the pension, as well as I think goes into much greater detail as to who with this proposal would apply to. The original bill just simply said a public official, and then leave it up to us in later statutes to determine who a public official is. What we are debating tonight, considering tonight, actually has a very extensive list as to who is included in this, and it includes officials filling elective office. Use a term, for example, people appointed by the governor of the state with or without Senate confirmation. Also, county, city, town, village administrators or managers, the equivalent. So I guess my point is that by passing this version, we're really handcuffing ourselves to any type of modification for the future unless we go through the whole amendment process all over again. I'm wondering why what we are doing tonight is preferable than a more open and general amendment that allows the legislature to do laws as we do from time to time.
Mr. Speaker, I'd point out that in March of 2015, the state legislature and the governor agreed on the implementing statute for any constitutional amendment that involves pension forfeiture. And so, in fact, at budget time last year, we implemented that statute with provisions saying it would go into effect upon adoption of the constitutional amendment. And virtually all the procedural provisions in the statute that was adopted are incorporated into this constitutional amendment. So those procedures were worked through. In fact, we've had on the books since 2011 a pension forfeiture statute that applies to public employees who enter the pension system after 2011. So that's been on the books for now 5 years. There's been time to review it. There were some changes made in March of 2015 that helped inform the process for crafting this constitutional amendment. So I certainly, as someone who supports many versions of this constitutional amendment, I understand that there are arguments as to whether to have all those details into the constitutional amendment, but I would say it's been consistently for a year the position of this House to try to make sure that there is clarity as to how pension forfeiture would work, and I think that's what's reflected in the resolution before us.
And just also point out, the way that this proposal is set out, looking specifically at page 1, line 15, it really doesn't state that this is actually a complete forfeiture. It really puts a great amount of discretion to a judge. I guess we're supposing the judge, assuming this official is convicted of a felony, and then there has to be a first determination as to whether his felony is connected to the public office, correct? It's not just going to be a public official convicted of any felony. There has to be some sort of relationship between the office that they hold and the crime they're convicted of, correct?
Correct. It has to be a felony committed in direct connection with service as a public officer.
But then when you go to line 15, it states that the court determination whether to reduce or revoke such pension. So it's not necessarily guaranteed they're going to lose that pension. It's going to be a judicial determination whether pension is revoked or just merely reduced, correct?
That's correct, and I think that's completely appropriate. The determination as to the relationship of the person's crime, the felony that's been committed, to their service to the public is something that we should entrust to judges, just as we entrust to judges decision as to how long the person might go to jail or what restitution they have to pay. The constitutional amendment is designed to provide the flexibility because there are obviously many circumstances that could be implicated by this, and ultimately an individualized determination is most appropriate. Obviously, there are some folks who have thoroughly not upheld their oath of office, and to them, I could see a very strong argument to remove as much of their pension as possible. But that might not be the case in all circumstances, and recognizing we can't foresee the future for all folks that this might apply to, we want to make sure a judge who oversees that particular case is able to make the appropriate determination.
Well, I think one, I say, difference between, for example, when we go and we pass statutes in the penal law and we'll for certain crimes, we'll tell the judges you have certain sentencing minimums and mandatory and maximums. So, for example, certain crimes may be 1 year to 3.5 years imprisonment. 5 to 15. But the way this language is written here, certainly revoke would be a 100% diminution, but reduce could be any amount. It could be, 95%. It could be 5%. So in this sense, we're giving a great amount of judicial discretion. I would say greater than that when we have a person convicted of crimes in the penal law. Wouldn't you say?
Well, I would point out that, first of all, the current rule under our Constitution is that automatically, under all circumstances, corrupt public officials are entitled to 100% of their pension. We need to amend the state constitution to address that. That default is absolutely at odds with what I think most New Yorkers believe. And by adopting this constitutional amendment, for a great many public officials, we will be saying that that's not acceptable. Understand, though, that on the flip side, we're not going to go to the complete opposite, automatic total forfeiture. We're going to allow individual circumstances to prevail, and ultimately, in part because I believe that this constitutional amendment is designed to support public trust in government, I think we also have to convey trust in our judicial system to make sure that justice is served.
And just finally, to make clear, we are on a little bit of a significant time constraint as far as concerned. As we are aware, in order to amend the Constitution, you just simply can't do it in a few months or even a year. It requires 2 successive legislatures of this body in order to make that occur. So if we were to go and enact this and the Senate enacts the same exact version, we would then have to do this again in 2017, and presumably this would go to the people of the state in the November 2017 election, correct?
Well, that's a general outline for sure. Exactly when the referendum on this constitutional amendment would occur would be up to the second edition of this state legislature. But I will say that's a very significant difference this year versus last year. Last year, when the Assembly and the Senate passed 2 different versions of the constitutional amendment, we knew we had another year to work through any differences. And that year wouldn't slow down the ultimate progress of this constitutional amendment. Now, with an election obviously forthcoming later this year, we do have to have agreement between the Assembly and the Senate in order to make sure that we are effectuating the will of the people of New York, and that's why I'm pleased that we are heading in that direction.
Right, because we do not do it this year, and it doesn't get accomplished, and we wait until next year, the earliest could possibly happen would be in 2019.
Correct.
Because then in 2017, we have a legislature which meets from 2017 to 2018, and if that legislature passes it, then the succeeding one, which is actually 2 legislatures away in 2019, and I think certainly we have a public which is very frustrated, I guess, at the pace that this has happened already.
That's correct. Further delay would not be in the interest of fighting corruption in New York State.
Thank you. Mr. Speaker, on the bill.
On the bill, Mr. McKevitt.
I certainly commend the sponsor for quite some time has been making the efforts in order to try to go and bring pension forfeiture to the floor. I think the people of the state have made very clear that they will accept no less unless we go forward with this. I would just note that the way that we have written this, or the way this has been written, is a very, very detailed statute which really goes and does confine us for many years to come. It's not how we ordinarily draft portions of the Constitution. And again, the way this is done, maybe, 4 or 5 years ago, in order to go make changes in the future, we may have some difficulties doing that. So just one thing to consider as we're voting on this bill tonight. Thank you.
Mr. Daniels, stay.
Thank you, Mr. Speaker. Would the sponsor yield?
Will you yield, sir?
I will, Mr. Speaker. Thank you.
Sponsor yields.
Thank you, Dave. It's been a long, strange, twisted journey that we've all taken to get to tonight. I first congratulate you for your efforts. I know that you've had this and several other versions that I've been co-sponsor on all of, and I've had a bill of my own. I won't belabor some of the points that my colleague just made, but I do want to make sure that we emphasize a few things. This version, and just for everyone's clarity, this version of the bill that or the resolution that we're going to consider tonight is identical to the one that we took up a year ago in June last year, post-budget, that is different from the budget version that the Senate passed in the sense that the Senate version was broader in scope, less limited. It applied to a wider number of state retirement members, and this bill has been crafted to be significantly more restrictive. Is that fair to say?
Well, I would also
More restrictive.
I would say that, with the exception of potentially the last statement, been largely correct. The one thing I will point out, though, is this amendment has been crafted in part with an eye towards actually getting it enacted into law. And as someone who believes that ultimately the goal of all of us as legislators is to produce results, being able to achieve that is as important a part of the drafting process as anything.
I couldn't agree more, but now I've got a question as far as actually being drafted or crafted into law. Certainly, you don't think that the public would have an issue passing this version or the Senate version into law, do you?
I believe that the public of New York, upon being presented a pension forfeiture constitutional amendment, will pass it overwhelmingly.
Any version of would likely to pass. But, I mean, the Senate version, certainly, the Senate indicated 14 and a half months ago that they would pass the more restrictive or broader version that captures everybody. So if we pass the same version that the Senate passed 14 and a half months ago at budget time, well, I don't understand what the obstacle you perceive to the Senate version becoming law.